Today we're going to talk about the probate process, and this really raises that question of how we want to arrange our affairs for someone to take care of them after we pass away. I had a friend who had come to the conclusion that he didn't want to buy life insurance because he actually wanted his family to miss him when he passed away. Now, he was actually just kidding, and he was a great dad, but he did have this angst that he didn't want people just living high on the hog and not even remembering him, when he had passed away. And so I think for each of us, as we come to that place of really grappling with our mortality and thinking, what are those steps that I want to have in place so that my family can be able to manage through that difficult season as easy as possible.
Right.
We want to surface probate because oftentimes clients will come to us and they'll say, well, I have a father or mother and they're not in good health. What happens if I'm named as the personal representative, or another word for that would be executor, of their estate? What process do I walk through? Or they might be thinking about their own mortality, and they may be wanting to, again, make sure that that son or daughter or other loved one has an easier path in terms of managing that probate process. But before we go there, we want to take a step in a side direction and say, well, you might not need probate depending on how things are set up. So we divide this into 4 different ways that assets might pass in terms of those financial resources moving from one generation to another, one person to the designated beneficiary. So as I mentioned, that first way of the 4 would be through a beneficiary designation.
Yeah.
So if you have an IRA or a 401k or a 403b or a life insurance contract, they're going to ask you at setup, who do you want to be your beneficiary or beneficiaries?
Yep.
It's actually a contract that you're entering there, and that contract has certain stipulations in terms of who you name as the beneficiary. Now, you don't have to name a beneficiary. Those assets, if you don't name one, would go to your estate, but most people are going to name a beneficiary for a variety of different reasons. The thing that we always come back to in reminding clients is that if your beneficiary designation there for that particular account is different than what you put in your will, the beneficiary designation is going to supersede whatever's in the will.
Right.
So we have to be really careful with that. But beneficiary designations, a lot of our clients, a significant part of their assets, if not the vast majority of them, are held in investment accounts. And the beneficiary designation would then dictate where things go. Now, that can be, again, IRA, 401k, different types of investment accounts. It can also be with non-qualified accounts, after-tax accounts, where we name a transfer on death designation. We have a beneficiary essentially that's named there. For bank accounts, that's usually called a payable on death or a POD designation there. But all of those pieces don't go through probate then if we're naming that individual beneficiary. A second way that we talk about assets passing would be via operation of law. Okay. Let's just say that you have a property that is jointly owned and you have a spouse or another loved one that is the survivor there. Then usually you just need the survivor would need a death certificate and be able to present that to be able to have that asset retitled in the survivor's name. So one of the things sometimes clients will ask, well, how do I make sure that that's right? How do I make sure that, it's titled correctly? Usually if you have the or statement there, let's just say we have John and Jane Jones, creative names here, John and Jane Jones. We would say John Jones or Jane Jones, or you could say John Jones and Jane Jones with right of survivorship.
Right.
That's typically what an attorney would help you do as you set up, that titling, that designation. So operation of law would be a second one. Again, that's not going to pass through probate there. A third one would be trust directions.
Yep.
So let's say your assets are owned by a trust that you've set up, and whether this is a revocable or an irrevocable trust, if the trust owns the assets, it's not going to go through probate in most circumstances. So you're not going to have a circumstance where it goes to the estate unless there's something weird and the trust then directs assets to go to the estate, which is very, very, very uncommon. So generally speaking, if the trust owns the assets, what you have is a trustee and then a successor trustee that then makes the decisions, and the successor trustee looks at the trust document and says, okay, where does the trust document say these resources need to go? after the death of the grantor or the trustee there that has been set up. So that's a third way.
Okay.
If none of those apply, now we're finally to the place where we're talking probate.
Okay.
So probate is kind of that last step there. And probate is usually something that would apply to, say, a home, because most homes, at least among our clients in Tennessee, they're not owned in a trust. They can be, but oftentimes we find that clients don't choose to put them into a trust. Sometimes there's also other assets that are not owned within a trust or are not passing direct to a beneficiary.
Right.
Sometimes that might be a bank or credit union account or those kinds of things. But probate then is that process where we look at a will and what you've put together in that will to name all kinds of different pieces of that to empower that next generation to make the decisions on your behalf and be able to parcel out the resources and the responsibilities as well.
Right. So if you haven't picked up yet, there's a lot of complexity when we think about passing on resources to the next generation. We'll have videos that are going to describe this in more detail that are forthcoming. But what we really want to say is there is complexity here. And so we wanted to lay that out first, but now we're going to dive into the actual probate process. So Spencer, you want to lead us into that?
Right. And as we look at this, we're looking at state of Tennessee. Yep. So every state has their own particulars. Your state, if you're outside of the state of Tennessee, could be very, very different or somewhat similar.
Yeah.
The same thing can apply to the way that we would help you plan, because some states probate is really expensive.
Yeah.
In the state of Tennessee, it's not.
Yeah.
And so we're much more open to people moving through the probate process with the value of their home. Whereas if you're in a state in the Northeast or far out west, sometimes we would lean much more towards a revocable living trust so that we can get all of the assets that we can outside of that probate process.
Great. All right, so Spencer, take us through a little bit of the probate process for Tennessee.
Yeah, so what eventually happens is that the personal representative, another name for that would be the executor or executrix, will take the will and set an appointment with Chancery Court and present the will to Chancery Court.
Okay.
That will give Chancery Court then the opportunity to be able to name that person as the personal representative and get that process going. So once they're named as the personal representative, they're also then issued letters testamentary, and those are the documents that then they can take to the financial institutions, present those that indeed they are the person that has been appointed to lead the assets and process of moving the estate to completion there after the person's passed away. Now, of course, there's other pieces to this. It's not just the assets. If there are minor children that need to be taken care of, then obviously the court's got to intervene and get more involved there.
Right.
There could be a dispute, among family members if there hasn't been a unified plan that's presented there. These are aspects that we don't typically get into because our clientele oftentimes is moving towards retirement or not too far from it. And so kids are out of the home oftentimes as we see things there. But that's the general process that we get into. If we take a little bit of a step back, there's also some other things that we really want to encourage people to do, even as they think about what do I have in my will and what is the process to kind of help my family after I pass away. You want to talk about that for a moment?
Yeah. So as you think about things that you aren't going to put in your will, a password to your computer is not going to be put in your will. Just the steps that you want to take for your funeral, for burial, for cremation, those don't need to be put in your will that are then public for everybody.
Right.
So when you think about all of these things that are really important that you need to communicate to your executor or executrix, you need to communicate, okay, where are those documents stored? Where is the original copy of your will? Where can they find passwords to your computer? Where can they find instructions for what you want to happen at your funeral?
Right.
Like these are things that don't need to be in the will, but are just as important so that your end of life decisions, your desires for your end of life are met. And it just is helpful for your executor and executrix.
Right.
They don't want to be spending the next 4 months trying to find your will.
Right.
It needs to be easy to find. So that also brings up a crucial point that you really need to be communicating these things with those important people, and probably more than one. And so really figuring out who those people are, those trustworthy people that you're going to name.
Right.
But then we'll talk about this quite a bit. The relationship is really important, and communication is really important.
Right.
All right. So Spencer, as we think about the timeline for how things pass through probate, what can an executor and executrix expect?
Yeah, so overall, we try to set expectations up front that it's probably going to be at least a 6-month process.
Okay.
I think state law in Tennessee is that you have to file the will with court within the first 10 years of a person passing away. So you've got a long time frame that you could file the will. Of course, most families want to do that as quickly as possible to get that process started.
Right.
But there are different hoops that you've got to jump through. And the key one that keeps the process open typically for about 6 months is that you've got to notify creditors. Oftentimes, if there's a list that's provided, then that can be a big help that you're notifying those creditors. For a lot of our clients, they really don't have creditors. I mean, they have a credit card bill, maybe that they pay off on a month-to-month basis. Maybe they've got a little bit of remaining amount on a mortgage, although oftentimes it's paid off by the time they pass away. So if you have a list of those pieces, that can be helpful. But the process, Tennessee basically wants to protect creditors having enough time to make their claims known and then those be paid off before an estate is closed. So oftentimes what will happen is you go through that process, you go to Chancery Court, the estate process begins, probate opens, and then you're posting or working with an attorney to post notification in a variety of different newspapers or announcement places that indeed this person has passed away.
Right.
And that gives an opportunity for any creditors that maybe weren't known to be able to come forward and say, actually, this person owed me some money.
Right.
You need to pay it off.
Okay.
So that's the general timeline and process. Usually as things open up and as you've got a number of months that that process needs to be open, once we get to that place where creditors have been paid, there's been sufficient time. If there's not any other complexity, like there's not a contest from one or more heirs that the will wasn't valid or something like that, oftentimes around 6 months, there's been enough time and assets have been able to be put into estate counts and there's an understanding of where they need to be dispersed, that an executor can begin to work towards the closing of that estate, can come back to court and petition the court to do so.
Great. So it seems like there's a lot on the shoulders of that personal representative. Do you want to unpack a little bit more of what they need to do, what they need to be aware of, and especially for someone naming a personal representative, maybe what are the important things as they're thinking about this next person?
Yeah, so there are a lot of different pieces to it. Law says that within 60 days of filing the will, the executor must notify any person named as an inheritor in the will and, go through this process of being recognized in state law. So there's a reaching out, obviously, to the beneficiaries. Sometimes there's some intense family emotions, about things, believe it or not. Sometimes it can get dicey there. And so at a minimum, what we encourage folks to do is work with an attorney on the process in the state of Tennessee. Sometimes this may just be that you have an initial meeting with the attorney. They tell you the different steps. You feel competent to do that. Then you connect with them towards the end of that process. And maybe you just have 2 billable hours for the attorney and it costs you, $500 or something like that. Sometimes you actually engage the attorney to do a lot of these different pieces because that attorney has a lot of experience there. So we have had situations where we have an out-of-state beneficiary that hires a local attorney to lead that whole process through. And the beneficiary, who would be named as the personal representative, they still are the personal representative, but they're really outsourcing so many of the key details and the counsel to the attorney. That's a little bit more expensive, but the feedback that we've received is that most of the time it's worth every penny there, rather than having to come back and forth many, many times, in-state travel, figure out all of the details that are, rather foreign to that person. So there is a significant weight that's laid on that person. Now, we have seen plenty of circumstances where if it's a a family and we have a beneficiary that's also named as personal representative, they can move through the process.
Yeah.
It's a learning curve for them, but oftentimes they can do so with just kind of the light counsel of an attorney there and some troubleshooting if things should arise there overall.
Great. So as we think about just the timing of all of this and the cost of all of it,
right?
What are those timings and cost?
Yeah. So, part of this, there's a wrinkle here in the event that folks did receive care from TennCare, in the midst of this gap. That can be one of those additional costs that, the estate has to recoup the cost of TennCare. Yeah. If there are some extra expenses, that's not typical for our clients. They're typically paying for long-term care out of pocket. But if there was a circumstance where they didn't have assets to do so, and their home was later sold and then, needed to recoup TennCare, then that can be, one of those pieces there. If we think about the overall costs, if you're in Knox County, starting the probate process by filing the will in Knox County is $250. Again, we talked about kind of the sliding scale of how you engage an attorney, and they're paid on an hourly basis,
right?
Typically. There are some attorneys that will just say, hey, here's my flat fee for dealing with all that comes here. And so you put them either on a retainer basis or you pay for an entire package there of services of just moving the estate through probate.
Yep.
So that's another way that it can be done. And every attorney is going to have a different approach there. Some that are really specialists in that area can be more expensive, and you might need that in certain circumstances.
Yeah.
For some that are more generalists, the cost may be a little bit less there. But we're happy to be able to make referrals based on what might be the right fit for clients as they approach these decisions.
Great. So Spencer, what if someone dies without a will?
Well, the good news is this is one of those freebies. Not too many things are free anymore, but the state of Tennessee, the legislators, the good men and women they have drafted you a will.
Great.
If there is none that you have
Fantastic.
drafted. So it's a free will. Now, their concept of where your assets go may not be the same as what you were thinking.
Yeah.
But it doesn't matter if you don't draft the will. Yeah. So this is this 50-cent phrase of the day, intestate succession, easy for me to say. But it basically, you die without a will.
Right.
And there's a whole process, of course, that the state has put in place because something like half of all adults don't have a will.
Yeah.
And so, it would shock you that there are plenty of people that we sit down with as new clients that they don't have a will and they've never had a will.
Right.
So our encouragement is always to have a simple will, at least that's drafted, make some decisions about beneficiaries, make some key decisions about who you would want to be leading your estate through the probate process, should there be assets there. So if we look at the state of Tennessee, the general idea, they're going to say, okay, well, if you die without a will, if you have a marriage with no children, then all assets are going to go to your spouse.
Yep. All right, so Spencer, what about estate taxes? This is a question that I think we get a lot. And the reality is, for most of our clients, it doesn't really matter.
Right.
But what happens with estate taxes?
Yeah, it's one of those questions that we get so often. And the good news is that in the state of Tennessee, we don't have an estate tax. We don't have that inheritance tax. I think that sunsetted or was put to rest, in 2016. Now, on the federal side of things, we still have estate tax. And so the nice thing there, for the time being at least, through I think the end of 2025, is that we have the first $13 million per person. There's an exemption. So if you have a married couple, it's I think between $25 and $26 million this year in 2023. For an individual, it's just south of $13 million. So that's the first thing, is that if your estate is south of that, you should be in good shape, not having any estate tax that would be due, because that's the exemption amount. Now, if you're giving assets to charitable institutions, again, that doesn't even count towards that $13 million.
Right.
So you get even more latitude, if you've got some of your estate going to charitable institutions.
Yeah.
Now, we do want to note with the Tax Cuts and Jobs Act expiring at the end of 2025, that amount will be halved at that point. So it'd only be, between $6 and $6.5 million in today's dollars, if we fast forward to 2026 and Congress doesn't change things up.
Right.
So that would apply to more people. Who knows what Congress will do? But one of the things that we always come back to is, well, let's think about doing living and giving through the course of time. Right. And I believe it's $17,000 that we've got that can be gifted this year per person.
Right.
Without that contributing to that ultimate number in what can be passed, estate tax wise. So it shouldn't be an issue for a lot of clients that are out there. But again, if you're in that circumstance where you need to be thinking about that, if you're one of our clients and we are surfacing that, and if you have questions on that, don't hesitate to reach out. But again, that's not an issue for most of our clients.
Right. So we've talked about the probate process. We've talked about what happens when you have to go through it. Some clients want to try to avoid probate at all costs.
Right.
What are maybe some ways that we can avoid probate?
Well, we talked about it at the start. If we have beneficiary designations, then those assets are going to pass not through probate, but to the named beneficiary.
Yep.
The second thing that we can do is, even if we own a home or we own assets that would often go through probate, we can have those put into a trust.
Yep.
So that's one of the ways that we can kind of get around that probate process. And again, that can be important in different states that are outside the state of Tennessee. It can also be really helpful in the state of Tennessee. If you don't want your estate plan to be public knowledge, when you go through that probate process, it is public knowledge.
Right.
Your will is public. If you would rather pass resources via a trust that's not public, then if the assets are owned at your passing by that trust, that's not public.
Right.
All of that information doesn't need to be public in most circumstances. So that's one of the helpful things. Of course, for some clients, they have a beneficiary who may not be able to handle those assets, take care of them, manage them, and so they're already going to have a trust set up, and you're going to have a trustee that's named that's able to take that burden going forward for that beneficiary. So there are really important reasons to explore having a trust. There is some creditor protection oftentimes for folks that receive assets that are in trust. So if you've had assets that are trust and they're passed on to the next generation, sometimes there is creditor protection there as well. So there's a variety of different reasons that we could look at putting assets into a trust to avoid that probate process.
Yeah.
But in the state of Tennessee, the expense dynamic is not really the driver.
Yeah.
It's these other factors that we might want to explore if they're not desired, again, by the owner.
Great. Well, thanks for that overview, Spencer. I hope that all these details didn't overwhelm you too much. If you have any questions about this, if you're one of our clients or you just have questions about probate, feel free to reach out to us. We'd love to help you out with those, and we will see you again next time. One thing to note as we close out, Spencer and I are not estate planning attorneys. We cannot draft a will for you. We cannot draft documents, any of those things. We're happy to look at them. We're happy to give you our counsel about what you should maybe take back to your estate planning attorney and talk about. But we can't make those final decisions for you.
Right. We'll give input. We'll raise our hand and say, okay, we see a red flag here or here because maybe there's something that is obvious that doesn't align with what you've stated are your wishes. Yeah. Or oftentimes we'll find that one of the designations of a personal representative, that person may not be appropriate to serve anymore because the will was drafted 5 or 10 years ago and that person's not the right person anymore. So we're happy to get engaged in that process and help you think through next steps. However,
we cannot do anything on your behalf. So take it to an estate planning attorney, work with an estate planning attorney, and we will see you next time.
Take care.
This content was provided by Retirement Planning Services. We're in Knoxville, Tennessee, and you can visit our website at www.seriousretirement.com. The information in this recording is intended for general educational and informational purposes only and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents.